Yes, hello everyone. Welcome to Rashid Matselele Connect. My name is Nahoho Rashid Matselele, and today we are going to be discussing a contentious issue that recently surfaced in the media, the Divorce Act, Section 20, that guarantees the restitution of conjugal rights. A Kampala lawyer and human rights activist known as Steven Kalali petitioned the Constitutional Court to declare this Section 20 of the Divorce Act that guarantees the restitution of conjugal rights as null and unconstitutional, alleging that it contradicts the current human rights democratic values. Now, before we go into a further discussion about this issue, I want us to first hear from his interview while addressing the media after he had submitted the petition.
This restitution of conjugal rights, it's archaic. It comes from a very old law. The Divorce Act was enacted in 1904. For God's sake, before even our independence. Most countries where we borrowed these laws from, like England, it has been outlawed because they say it's not in line with the current democratic rights that are attributed to human beings.
Well, that is a human rights lawyer and activist, Steven Kalali, explaining to the media after he had submitted the petition to the Constitutional Court. And as you have just heard, he says that this law is cruel, it promotes criminality, and therefore it should be abolished. Now, for us to learn more about this, I talked to a number of people, including legal experts, religious leaders, to find more about what really this Section 20 of the Divorce Act means and what does restitution of conjugal rights mean. I have teacher Godfrey Chaze, who is director Homeline Academy, and he is an educational expert and lecturer. Tim Rachel, who is a legal expert and advocate at Joy for Children, Uganda. And then we shall also be speaking to Sheikh Nuruddin Sabah, who is a missionary and legal expert at Ahmadiyya Muslim Association, Uganda. These are the people whom we are going to be hearing different views about Section 20 of the Divorce Act, which guarantees the restitution of conjugal rights. Now, before we continue, I want us to first get to know or understand what restitution of conjugal rights means. I think that is something very important that we have to first understand before we go into a deeper discussion about this issue. When we talk about the restitution of conjugal rights, it is found in Uganda Divorce Act, that is Cap 144, Section 20, which guarantees the restitution of conjugal rights. When you look at the first part of this section, it says that if a husband or wife has, or without reasonable excuse, withdrawn from the society of the other, the wife or husband may apply by petition to the court for restitution of conjugal rights. And then the second clause in the section says, the court, on being satisfied that the allegations of the petition are true and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. Nothing shall be pleaded in answer to a petition for restitution of conjugal rights which would not be a ground for a suit for judicial separation or for a decree of nullity of marriage. Now, we want to have an understanding of what restitution of conjugal rights means in a layman's understanding. And I bring in Sheikh Nuruddin Sabah, who is a legal expert and also a missionary at the Ahmadiyya Muslim community, Uganda, to explain more what restitution of conjugal rights means in basic terms.
Dear viewers, I welcome you also to this program. Thank you very much for hosting me here. When you look at this issue, restitution actually is found in the Divorce Act, and it's one of the remedies that is given to the aggrieved party who, let's say, has been deserted. Of course, for any, let's say, he has no or she has no reasonable excuse, but they desert from their home, matrimonial home, they go away. So the court can come in and, upon of course the petition of the aggrieved party, direct or order the other partner to come back and, of course, fulfill the rights. Here we are talking about the conjugal rights, and but as we know, desertion is one of the ingredients or grounds that brings up a divorce.
Okay.
Before people, before there is dissolution of marriages, they will have to look at certain factors, some of which desertion is part. If, let's say, someone is being found guilty of adultery, someone has been found guilty of bigamy, and other factors, of course, as provided by the Divorce Act. You can read section 4.
Yes, that is Sheikh Nuruddin Sabah, a missionary and legal expert at Ahmadiyya Muslim Association, Uganda. This law was inherited from the British legal traditions. That's why when Steven Kalali was explaining that it was enacted in 1904, before even independence. Apart from Steven Kalali, I also had an interview with Atim Rachel, who is a legal expert and an advocate at Joy for Children, Uganda. And she also agrees with Steven Kalali that this section 20 of the Divorce Act actually violates fundamental human rights like privacy, liberty, and human dignity.
About the petition and also the nullifying of the section 20, of course the petition says that forcing someone to live with the other person, or maybe the spouse, or resume marital relations is against human rights, or it goes against human rights. And of course that's the case, because if you are forcing someone to go back into something they left, then that's against their right. Of course, you're going against their right of being of making their own decisions. You're going against their rights of also being treated with dignity. So I know the law maybe might be looking at it from this perspective of bringing people together and also keeping families together, but at the end of the day it can be harmful. People have different reasons as to why they leave different spaces. So if you are forcing this person to go back to where they left because their reason is not justifiable, then people don't talk about different stuff. I won't come to you and tell you, maybe people were fighting about, let's say, a toothpaste. She left because they were fighting about a toothpaste. When the law comes in and asks what's the reason as why you left this marriage, and then the other party who is asking for me to come back is saying we fought because of a toothpaste, but then at the end of the day I left maybe because of the reaction. How did this person react when before I left. You get? So there are different reasons as to why people leave. So forcing someone to go back can be harmful at some point. I mean, modern laws now are now focusing on individual rights, personal freedoms, you understand, and not, forceful reconciliation and forcing people to reconcile.
Okay.
So really, if the petition is there, I'm also happy to sign it.
Yes, that is a team, Rachel from Joy for Children, Uganda. And I think she points out something very important about this section, because it states that if at all the court finds out that the reason for one leaving his or her matrimonial home is unjustifiable, then the court can give a decree for her or him to go back. What is that which is justifiable to the court? For example, people fight in marital homes because of just petty issues, and you find out that it leads to separation, sometimes even divorce. However, there are also some other people who think that this law or this section actually is there to protect the sanctity of marriage. Among the people who have a different view from that of Steven Kalali and Atim Rachel, we have teacher Godfrey Chaze, who is a director at Homeline Academy and also an educational expert and a lecturer.
I think the extent to which the state should be involved in private affairs such as marriage, including conjugal rights, I think it should be to the degree that the state is playing its rightful role in as far as jurisdictions are concerned. And what am I referring to here? There are three institutions that are natural and are established by God in society. And these are the family, voluntary associations, most times the one we look at as non-state actors, but they bring people together voluntarily. These are associations like the church, the mosque, and all kinds of different clubs and groups and associations that bring us together. That's the second sphere. And the third sphere is the state. These three spheres, the family, associations, and the state, are natural and are established by God, but each has a sense of sovereignty over the other, in the sense that each has its jurisdiction, it has its responsibilities and roles it plays in society, that to overstep and play the role of another would be the problem. For example, the family should not play the role of the associations or the church. The church should not play the role of the family. And the state should not play the role of the family or the church. So how much should the state be involved in private affairs? I believe the state has three responsibilities. Much of what it should do should rotate around these three responsibilities. And what are those? The role of the state, whether it is to the family or to the church or to anybody, should be as far as protection, defense, and punishment. That's what the state does. It protects, it defends, and it punishes. What does it protect? What does it defend? It protects three things. The role of the state is to protect property, life, and rights. Natural God-given rights. So the state, as long as it's doing its duty to protect and to defend and promote people's rights, I think it is within its jurisdiction. Now, in as far as marriage and family is concerned, what is supposed to be protected and defended and punished here? Marriage itself is a property. Is a property that whenever people are getting married, you realize that all these three spheres get involved. The family, the church, for example, and the state. They all get involved. They all have a role to play. And the role of the state specifically is in as far as protecting the marriage, defending the marriage, and promoting the marriage and the rights of the married people, including conjugal rights. So when it comes to the state's involvement in a marriage, it is as long as the state is trying to defend the couple and defend their conjugal rights, to protect them and protect their conjugal rights, and to promote them having their conjugal rights, I think the state will be within its parameters to do what it should do. Now, is it possible that the two people who are married themselves can violate each other's right in as far as conjugal rights are concerned, and should the state be involved? I think so. It can go to the extent where it can be involved, but first of all, it is the two of you, it's your responsibility as a couple to make sure you iron out whatever issues that are causing you to deny each other.
Well, that is teacher Godfrey Chaze, and he has raised important questions in his statement. First of all, can two people violate each other's rights, especially conjugal rights? I say yes. I think there are times when these conjugal rights are violated. That's why the state is there to protect these two people. But again, he argues that marriage is a property of the state, and the state has a right to intervene as far as protecting the marital rights of two people. However, not everyone agrees with that view. Critics, the likes of Tim Rachel, argue that if the state is forcing people to go back to their marital homes against their will, then that is not protecting their rights.
I think the state is supposed to be protecting people, right? Protecting people and their rights as well. The state is supposed to be protecting me from abuse. You understand? So if because the law is made by the state, so if the law comes out and then they are forcing me to go back to a space where I was abused, is it protecting me? No, it's not. Also, when it comes to conjugal rights and intimate things, the law is not supposed to force me to do that. It's not supposed to be forcing people to do that, because that is so private. It's supposed to guide and protect people, but not control their private life, mostly when it comes to marital life. That's something so personal, and that is something that can be solved between me and my partner.
Wow. In other words, Tim Rachel argues that the state should have very, very limited involvement into marital issues, especially when it comes to cases of conjugal rights. And this is where now the debate becomes more heated up, because now we have, on the one hand, a perspective of marriage as a legal contract. And then on the other hand, we have a moral and emotional perspective of marriage as a partnership. When we also recall the words of teacher Godfrey Chaze, he says that there are three entities in society. Of course, each has its own boundaries, and that he mentions the state, non-state actors. Now here we can say religious groups and cultural institutions, civil society organizations, and others, and then the family. He says that these three, at different stages, they are always involved in marital issues. Now, that means that we come to an understanding that marriage is not just a legal contract, but marriage has a strong spiritual component. It has a strong family component. It has a strong cultural component. Now, I also try to find out to what extent should religious institutions get involved into marital issues. And here I specifically focus on the role of the church and Islam. How far should they get involved into marital issues?
Islamic marriages, first of all, are based upon love, mercy for each other, so that you can have peace. Meaning, an Islamic man and woman goes into marriage with the intent that I want one, peace, two, there should be mercy for each other, and also that love. That is what Allah has taught us in the Holy Quran. In fact, in chapter 30, that is Surah Rum, verse 22, you will find that Allah says, وَمِنْ آيَاتِهِ أَنْ خَلَقَ لَكُمْ مِنْ أَنفُسِكُمْ أَزْوَاجًا. Allah, among His signs, He has created spouses for us. If you are a man, He has created women. If you are a woman, He has created men. What is the essence of this? لِتَسْكُنُوا إِلَيْهَا. The essence of these spouses, so that we can get peace in them. So you enter marriage because you want to have peace of mind. So someone who has entered marriage forcefully cannot have this peace. And that is where you will find the issues of desertion leading to restitution. But for Islam says, when you enter into marriage, then you should have love for one another, peace for one another, you should have mercy for one another. That's why whatever happens during marriage, you will have to sort yourselves because there is love.
Okay.
If, let's say, love has decayed, at least you have mercy for your partner. If there is no mercy, at least there should be love or friendship or in another way.
Well, we have had now two different views from the Islamic side and the Christianity side. But there is something which is similar between these two differing views, especially during a time of marital disagreements. Now, two people within the family in marriage, before the third party comes in, they should have that ability whereby they can sit each other down and then try to reconcile before the third party, let's say the state, legal frameworks, or the church, the mosque, the cultural leaders, and other family members come in to sort out issues. But what if reconciliation by these faith and family members, cultural institutions fail? Should the state just sit back and just look on, or should it intervene?
In the event that two people are separated who are married, what should the state's role be? Should the state force one party to go back to the other party? I think there are two things. There's a difference between divorce and a separation. Marriage is when we come together to get married, and the state has a role it plays to stamp into the marriage. And when it stamps, when we allow the state to come and stamp into the marriage, we are acknowledging that the state has a role to protect, defend this institution, but also to punish whoever violates it, and to protect this institution of marriage. Now, in the event that you're going to separate or to divorce, which is the legal separation, still the state has to be involved. And when it is not involved, then you are not divorced. Maybe what you've done is simply a separation. Now, what is a separation? A separation, you're still married. You're still legally married when you separate. And because you're still legally married, the state has a duty to still protect your marriage. How does it protect it? By keeping you together. you want to look at it like it forces you. It's not a force. You already voluntarily accepted to be married to this man. As long as you're still married to this man and this woman, the state, the only thing it can do, for example, if one of you goes to the state and say, my wife, who is legally my wife, is no longer staying with me, and I don't know where she's staying, I think the state has a role to force you back until you give it a higher reason as to why you should not stay with this man. Which reason? That could be like a court of appeal that can lead you to divorce. But without that legitimate reason, as a bona fide married person to your bona fide married partner or spouse, the state has the duty, if one of you goes to the state and asks for help, the state has a duty to bring you back together, because legally you're married and the state is supposed to protect that marriage, to stay together, unless you give a reason for the state not to let you stay together, which reason can lead you maybe to divorce. But just a separation, you have no much reason to say the state cannot force me back, because you are already one. You've already accepted to stay with this man, with this woman. You must have a reason if you seek to separate.
Wow. I like that. If you have no reason, you have become one. There's no need of you running away from the marital home. That is something very, very interesting. Now, as we come to the conclusion of this episode, we have had two sides. We have the supporters of the restitution of conjugal rights, who argue that this law is there to encourage a reconciliation between couples, and then it protects marriages as a social and legal institution, and it also prevents hasty divorces and offers time for reflection, such that the two couples, the two people can go back together. We also have the critics, the other side, who argue that it violates privacy and bodily autonomy, and it can enable abuse by forcing one spouse to return to the marital home unwillingly, and then it treats marriages as ownership and not partnership. I understand that those who formulated this law, restitution of conjugal rights, the main intention was to enable marriages to stay together. But now, as the world develops, and now the issue of human rights, especially civil liberties, is a great concern in the modern age. So I think there's need to strike a balance between protecting the sanctity of marriage, as well as ensuring that individual liberties are also respected. But also beyond the courtrooms and the legal jargons that we have had in this program, I think now this challenges us now to rethink about the challenges that arise within marital homes, especially in this modern society. As Ugandans and society, regardless of our religious, cultural background, we need to have honest conversations about such issues. Do you think that restitution of conjugal rights should be abolished or retained? Share your views down in the comment box, and please don't forget to like, subscribe for more deep conversations and stories that shape our society. I am Nahoho Rashid Matselele, and this has been the Rashid Matselele Connect. Until next time.